Again, good afternoon, everybody. Everybody hear me okay? Or good morning, I guess I should say. So again, our litigants for the people of the state of Michigan, Ms. Marilyn Day, and for the defendant, Camilla Barkovic, please congratulate them. My name is Tom Clement. I'm general counsel for the Michigan Supreme Court, and welcome all. I want to thank everybody, Petoskey High School especially, but all of the surrounding areas. Welcome to the students, but thank you for welcoming us here to conduct a session of court before you. This is obviously very important work, and I can tell you each of the justices takes this incredibly seriously and is thrilled to be able to take this around to various places in the state of Michigan. We were down at River Rouge about 6 months ago, and we try to do this twice a year or so. It's a great opportunity not only for the students and the local officials to see how the court actually operates, but for the court as well to get around and to meet people and to see how their decisions truly do impact more than just those of us who work in the Lansing area. So I'd like to get down right to brass tacks with the litigants here and ask them what their general impressions were of the argument now that we're through it here. Ms. Day, you want to start?
Well, you know, I knew coming in that this would be somewhat of a hard sell, but I think if the court focuses on the fact that it was a driveway, then potentially we could have a successful opinion. But the reach of the statute is very, very broad. But that is an issue for the legislature to address, not this court. This court is required to look at the plain language of the statute. I don't know if you guys in your classes read our briefs, but I cited to a case out of Vermont where the Supreme Court of Vermont had indicated that a private driveway was basically accessible and open to the public. Well, what happened after that case came out is the Vermont legislature amended the statute and specifically precluded private residential driveways from their statute, the OWI statute. So the legislature can change the statute at any time, but the Michigan Supreme Court can't change the statute. They just have to interpret the case according to the plain language of the statute.
Ms. Barkovic, do you have any impressions?
And just following off what Ms. Day said, obviously I have a different interpretation as to what I hope the court does in this case. Obviously, as I articulated earlier, there are three specific areas the legislature specifically indicated that one can't operate a vehicle while intoxicated. Nowhere in that statute does it reference, obviously, the area in question in this case. And I think it says a lot about what the legislature intended by the fact that they didn't just simply say that one cannot operate a vehicle while intoxicated in all areas within the state. As you heard during our arguments, clearly there are statutes within which the legislature did do that. But I think the legislature had in mind when it enacted this statute that there were certain areas where this should not be made a crime. And I think that the area in question, 50 feet from the roadway, at the end of someone's driveway, right next to their detached garage and their side entrance to their house, essentially behind a fence line, I think that's one such private area that the legislature didn't contemplate criminalizing such behavior.
Thank you. And again, we're more interested in your questions than we are mine. So if you have any, please feel free to make your way down. Obviously, we spent a long time talking, or the entire time talking about that phrase, general accessibility. Ms. Day, I was struck by your argument that when you were talking after your first 2 minutes had expired, Justice Bernstein came right out of the gate, which caught me a little bit by surprise. And one of the first things he talked about was governmental overreach and started talking to you about that. And then we went on this kind of hypothetical journey where we talked about down by a lake, and you were challenged to answer questions about that and general accessibility. Justice Bernstein took you to a farm, a big farm, and tractors and this and that, and you were challenged on that. And I think a couple of other justices had you in different places through hypotheticals, and that took you through about 10 minutes of your argument, and they seemed to hit you on specifics over and over and over again where they would try to get you into a corner and then have you sort of back your way out of it. But then you came up with, or you put out there, general accessibility is meant or designed for vehicular traffic. And it seemed like that sort of stopped them in their tracks. Can you talk about that general test that you were speaking of there, and perhaps why that didn't come out a little bit sooner in your argument?
Well, it would have came out if I had finished my presentation before I got answered the question. But the issue in this case is a driveway, and the driveway is so clear that the statute applies because the legislature has defined what a private driveway is, and a private driveway is defined as used for vehicular traffic. So if the legislature has already defined a piece of property as used for vehicular traffic, it by necessity has to be generally accessible to motor vehicles. And to not go down the rabbit hole of the farm field and everything else. This case was a MOA. They haven't even granted a full leave grant on this case. So I was trying to keep the justices focused on driveways, and not just defendants' driveways, but any driveway. A driveway, the word itself means drive. You're driving on a driveway. So a private driveway, by necessity, is generally accessible to motor vehicles. And if I could get an opinion from the Court of Appeals or by the Supreme Court to say that, I would be very, very happy. There are many, many other scenarios that, potentially there could be fact questions on let's say there's a car in the back 40 in the middle of the field. Okay, is that generally accessible? It might depend on some facts. That might be a fact question. But a private residential driveway, that's as a matter of law, generally accessible to motor vehicles. And if the court is disturbed about this, I don't think it would be, because you have to look at the plain language of the statute. And I don't know, ask any other questions you have, but the private driveway is obviously to me generally accessible to motor vehicles. And it's based on the definition already set forth in the motor vehicle code.
Thank you. And then, Ms. Barkovic, the first place, so when we're talking about this manner designed for vehicular traffic, so my question would be, one, I presume that was addressed in Ms. Day's brief. Did you respond to that in any way? And what is your response to that? But more importantly, one of the first places you went in your argument was to legislative intent, and then Justice McCormick and you had an exchange where she basically says there's potentially two interpretations of this generally accessible term. One you win and one you lose. She said that specifically, and you brought out the rule of lenity. And you said, well, there's 8 smart people up here, all lawyers, that are talking about this, and essentially what you were saying is, how am my client supposed to know what the term of general accessibility is if the rest of us can't figure it out? So is that generally the path you were going down, or do you care to expand on that at all?
Well, obviously, my contention is I think it's a little bit more than just simply a private driveway in this case. Sure, Mr. Ray may technically have been on a paved driveway. However, the portion of the paved driveway that he was on was encompassed essentially within his backyard. And so I think that, sure, maybe there are certain arguments that can be made to private driveways as a whole, but you have to look at the specific nature of the area in question. And when you look at that and you look at the facts and circumstances of this case, I think that the conclusion is clear, and that's simply that a large number of motor vehicles generally don't access the area, and I think that's what obviously the legislature was looking at when they enacted the statute, just given the nature of the categories that they set forth in the statute. With respect to the exchange with Justice McCormick, obviously the rule of lenity indicates that basically criminal offenses must be clearly set forth so individuals know what conduct is permissible and what conduct is not permissible. And clearly, just evident in the fact that we're here and that we are arguing, everyone probably on the stage may have a different interpretation of the statutory language, and under those circumstances, what the law says is that the statute should be construed in favor of the defendant. And so, as a backup argument, I set that forth.
Thank you. It looks like we have an audience question. Can you tell us your name and ask your question, please?
Hi, I'm Olivia Vargo. I'm from Boyne City High School. We debated this in class. We went through all the briefs and talked about all of that. What I'm wondering is why neither of you delved into the details of the case, because we know, I think that you mentioned when they asked you what is not generally accessible, then you mentioned like a gated driveway. What makes this case different is that the police officer was parked at the end of the driveway, barricading him from leaving. So even if he had intent to drive on the road, it was not possible for him to. So what do you say to that, and what makes this?
I think that's where you can use one definition of generally accessible. And it's not crystal clear because this has not been a full trial. This was just one evidentiary hearing, and this was a motion to quash. And basically with a motion to quash, you're only looking at the evidence from the preliminary exam. The hearing that happened in the circuit court, really you shouldn't even look at that for a motion to quash, because the circuit court judge is looking what the district court judge did and finding whether defendant's conduct fell within the statute, okay? In this particular case, the officer, it's not 100% clear if the defendant could not have backed out, but what is clear is the officer was walking up his driveway because of a third noise complaint. This isn't they were investigating a drunk driving case. There's no evidence that they were investigating drunk driving. They were there as a community caretaker function. There's no Fourth Amendment violations here. It was a community caretaker exception. They can go up on their driveway to talk to the defendant about what happened. When the officer was walking up to the door, that's when defendant starts backing out of his driveway, and that's when the police officer had to shine his flashlight so the defendant didn't actually back into him or the car. Okay, we don't know how far defendant would have moved down, and that's why our argument that this whole area is generally accessible to motor vehicles. Police officers making these split-second factual scenarios. If he had moved down an extra 10 feet, that would have been generally accessible, but because where he was, that was not generally accessible. And it mattered that he was backing down the driveway and instead of going forward. These are fact questions that should not be resolved when you're looking at an element of the offense. The element of the offense is a question of law that the court has to decide, and that's a matter of law, and it's not a particular fact question in this particular case. It's just a matter of law. And, and I know people have problems with us charging this type of cases, but it's up to prosecutor charging discretion, okay? I have been in the prosecutor's office for 23 years. I have gotten phone calls from the warrants department asking, there was somebody in the back field, he was all alone, should be charged, and we go back and forth whether to charge or not. It all depends on the situation, whether we as a prosecutor are going to charge. We believe that a driveway, as a matter of law, is generally accessible to motor vehicles, and he was driving on the driveway, and he's a habitual repeat offender. So we want to get him off the streets. He had 7 prior drunk driving convictions. He was been in prison 3 times and in jail 1 time for prior drunk driving. So we used our prosecutor charging discretion and decided to charge him because we felt that his conduct driving on a driveway is an area within the location set forth in the statute.
But then, with that mentioned, you decide what cases you're going to take. In what Judge Bernstein talked about, he talked about your definition of generally accessible was then almost every place in the state of Michigan would be a place that is generally accessible to motor vehicles. And if accessible is a place that you can drive almost anywhere. So going along with that, wouldn't you then have to take all of these cases?
It's a purely charging discretion. And the DNR code, we get those cases too. You're on your snowmobile, you're on your ATV, you're anywhere in the back 40 and you're drinking and driving, we can charge you, okay? Then the question is, why are we back in the back 40? That's a Fourth Amendment issue. That is whether the police have the authority to be where they are, okay? Technically, we can charge pretty much anywhere in the state if you're drinking and driving. And the reason is because the legislature recognizes how dangerous it is to be in a vehicle while intoxicated. And I'm not talking about one drink. I'm talking about the law that says intoxicated. You're impaired, you're under the influence, you have a .08. The Michigan Supreme Court has recognized that is grossly negligent as a matter of law. You're grossly negligent if you're behind the wheel of the car. And in Michigan, when you look at the word operate, it means actual physical control. So you don't even have to be driving a vehicle. It's a prophylactic measure to get these people out of the vehicles, because it's such a dangerous activity to be behind a wheel of a car while you're driving. It's not just a physical act of driving, but the potential that they could be moving out into the public or wherever he may be. And in this particular case, is it any less relevant that he's in his driveway? Say of his neighbor who was complaining about the noise complaints. Say if his neighbor was in the driveway and got hit. Can we not charge the defendant for causing a serious injury while intoxicated because it was his neighbor in his driveway? You should be able to charge in these particular cases. And it has to do with the vehicle. It's different from open to the public. That is when people don't expect cars to be in the lawn of the dormitory at Wayne State University. You wouldn't expect the car. So they have that open to the public. In a driveway, people expect cars to be in their driveway. So that's all, what's the expectation? And it's like I said, it doesn't lessen the culpability if he is in his driveway and hits his neighbor, or if he actually got out and was on the street and hits his neighbor.
And then,
It's a lot to respond to, but I can try. Obviously, it's my contention it's completely irrelevant whether this is the defendant's first operating while intoxicated charge or his seventh. Clearly, what's at issue is the law, and the law is something that affects everyone in this room, because obviously we would all like to know what is criminal conduct and what's not, especially in an area where some of us, may have been cleaning out our cars while having an alcoholic beverage, put the car in gear, and reversed maybe a foot. If the court were to rule or agree with the prosecutor, under these circumstances, even if we never even intended to go in the street and are simply enjoying ourselves on a Saturday afternoon, we're essentially subjecting ourselves to criminal prosecution. And I don't think that that is what the legislature intended to do with this statute at all. And once again, if they did, they would have said so. Another thing is, the student aptly noted that we didn't argue the facts of the case, and just for the students, obviously the justices are provided in advance with all of our written briefs and things of that nature, which include a summary of all of the facts relating to the case. I think it's an excellent observation that she made, that the police officer's vehicle was blocking the entryway and or exit way of the driveway, and so it wasn't accessible really by any means at that point in time, and that is something we did set forth in our brief.
Thank you. So we're running short on time. We have time for a few more questions, so I want to go over here. But I would just indicate if your questions we aren't able to get to it in this public forum, please stay back, and I think we'll have a few minutes that we can continue to answer questions that you may have. So,
Jonathan Shield, you've touched on quite a bit what I was going to comment on, but in rural Emmett County here, when you're talking about just driveway, we have quarter-mile-long driveways. We have also farmers who are on their back 40 driving licensed vehicles, hauling grain or working on, as you stated, working on, and so I see that possible on a Saturday afternoon or on a Friday or any other day, that there possibly could be alcoholic beverages and the possibility of being in that vehicle and moving it, but not necessarily a danger of harming other public. So I'm worried about that overreach. I want the public safe. I want to protect the neighbors. I want to protect children. I want to protect all of that. But I'm worried about the overreach of just calling because it's a driveway. Yep, that we can charge people, and that makes it an automatically offense. Thank you.
I think what you have to consider is the fact that you had a drink and are operating a vehicle. It's not what's criminally liable. It's when you're operating while intoxicated. And there's a specific, we all know what that means. It's a .08 or impaired. It's not just having one or two drinks. Let's assume you're totally, you're a .3 and you're in your back 40 or on the farm equipment or wherever. Yeah, I think we should, as a state, be able to charge you because you're dangerous, if not to the public, you're dangerous to yourself. And Michigan has never used a rule of lenity for the vehicle code. They don't use it for the public health code. They do use it for criminal statutes, but there's many states that said the rule of lenity simply does not apply for OWI offenses because it's so clear and obvious and dangerous that in fact it's a remedial statute and you have to strictly construe it against the defendant. So when you're looking at an action that's grossly negligent as a matter of law, I don't think it's too far-fetched to say if you're on a driveway which is normally used for vehicular traffic, then you can be charged with an OWI offense. Whether you are or not, I can't imagine you would be charged with an OWI offense in that particular case unless for some reason the police was called out to your property or if you hurt someone. If you hurt someone in your backyard while driving while intoxicated and you're on a driveway, you should be charged. And it's not state overreaching, it's a matter of public safety, either for yourself or whoever might be around.
Let's try to, if we can go over here and do...
Mark Antoni, Brook City. Just a quick question of procedure. I was really impressed with how quickly you were able to answer the judge's questions, and when they interrupted you, but neither of you got to your prepared comments. I think you had asked for 2 minutes reserved, but I don't know that you ever got it for your responses. Do you guys practice this in terms of having people interrupt you for questions at you? Because it was amazing how quick you were able to respond to the questions. Thanks.
Sure. Obviously, you can't anticipate what you're going to be asked 100%, but you can speculate. Obviously, the prosecutor has made arguments in the briefs that she's submitted to the court, and I've made them as well. And based on those arguments, I think you can see what the other side's position may be, and obviously you anticipate that you'll be asked to state why your position is correct and why the other one that's advanced should not be adopted. So it's definitely something that you can prepare for to the extent possible, but once again, I think that there are some wild cards that can be thrown.
Thank you. Come on.
Fortunately, our office is pretty large. We have over 100 attorneys in the Oakland County Prosecutor's Office, and I think we have 8 appellate attorneys. So every time one of us have argument before the Supreme Court, we always do a mock argument. So I got to practice this in front of 7 or 8 other attorneys, so they were asking questions back and forth, and that was very helpful.
Last question, because the justices are waiting, but for those of you who remain, if you want to come up and ask the questions, please feel free to do so. You name the question.
My name is Forrest Walker from Petoskey High School, and my question is, if the ATV and snowmobiling laws are so much more clear about the drunk driving, then why would they make the more popular the car drunk driving statutes so less unclear? Because if it's like the private property or the generally accessible, what do you think that they really intended?
That's a very good question, because I would love it if the drunk driving statute said anywhere in the state. But the DNR statute, it's a different purpose because they're like the snowmobile, they're regulating the snowmobile usage. There's no Secretary of State implications, so they can keep it anywhere within the state. And even for ATVs, there are some licensing sanctions, but it's not the same as regular, motor vehicle sections. It's interesting because when the OWI statute was amended to include the generally accessible to motor vehicles, the ATV statute and snowmobile statute weren't as strict. Okay, the BAC contest was 0.1 as opposed to 0.08, and the criminal penalties weren't as high. So after in 1992, when the OWI statute was amended to include the language generally accessible to motor vehicle, subsequent to that, then the ATV statute and those statutes were actually brought in line pretty much criminally wise with the OWI statute. But still, they had always used the language basically anywhere within the state. But it's different because you're looking, the motor vehicle code is a little bit different. They're trying to prohibit the the use of the vehicles, but recognizing that vehicles are used in private places such as driveways and private roads. And one thing Defense Counsel had said, I just wanted to mention that I didn't get to mention before, private roads are specifically identified in the Motor Vehicle Code as being open to the public. So when they amended the statute in 1992, that was already included. So they didn't reach in and grab those areas because they were already included before the statute was amended. So the statute had to have been amended for a particular reason. And I think the particular reason was to include those areas that are usually used for vehicular traffic.
Thank you.
All right, just a couple of finishing comments here, especially for the students that are here. I want to commend our litigants. I just want to impress upon each of you, I can't impress enough how much work goes into preparing for one of these arguments. You saw each of them up for 15 minutes in a very high-stress situation, high-pressure situation, answering a lot of very, very difficult questions. But I can promise you that for each of these women, hours and hours and hours of work went into preparing their briefs, preparing their arguments, and doing the argument that you just saw, not only in this court, the highest court in the state, but in 2 other courts as well, or at least 2 other courts as well. So I want to commend each of them. I thought they both did a fabulous job, and thank you again for coming up here and doing this and taking time out of your schedule.